protection by the Indian law, the need of an hour, in today's international conference on educational values and consciousness embedded in Vedic and post-Vedic thought. So, intellectual properties are the properties which are owned by a human brain, which are generally derived into different aspects like patents, trademarks, copyrights, geographical indications, trade secrets. Generally, it is found that these specific IPRs are controlled or governed by their specific acts. Like for patents, we have Patents Act. For trademarks, we have Trademarks Act. For copyrights, we have their respective acts. But the loophole between the other IPRs and traditional knowledge and as an IPR is there is no specific law or there is no specific legislation which is going to govern the protection of the traditional knowledge of India. So the traditional knowledge of India comprises of various aspects, like it is the different areas of knowledge considering of medicines, astrology, mathematics, architecture, agriculture, botany, zoology, metallurgy, environmental science, cosmology, psychology, management studies, and so on. Traditional knowledge is like a backbone for India, as India can be considered as a hub of traditional knowledge. Generally, people give only importance to the materialistic elements, materialistic assets, but India owns such a huge asset and such a valuable asset which has not been protected in this era. Due to these things, the aim of my research paper is to identify the need of protection of traditional knowledge, which should be governed and which should be covered by the Indian law, to enhance the laws which are specifying the traditional knowledge of India, and it should be named under Indian regulations and protecting for the betterment of the Indian citizens. To form and implement global legal framework, and it should be prevented the misappropriation and misuse of such knowledge worldwide. There are suggestions to documentations as we lack in the documentary evidences to prove so that the loss and erosion of such inappropriate changes in the knowledge can be strongly tackled and the challenges can be faced for the modernization and the cultural changes which we experience in overall day-to-day life. The paper also suggests about the actions which can be taken against the commercial exploitation of traditional knowledge as well as the benefit sharing provisions which should be protected under the Indian law. The methodology which is used for this research paper is empirical and analytical. The qualitative analysis has been done based on the secondary data through the overall literature review which is available through different books, different transcripts, different sources of traditional knowledge like Vedas, Upanishads, Smritis, Shastras, Purans, Sutras. So n number of books are referred for this secondary data collection. Some suggestions have been put for the legal provisions which should be implemented for the protection of this knowledge. The observations of the respective research paper is generally it is found that the traditional knowledge of India is being communicated in an oral form. It has not been documented systematically in a specific form which can be reached out to the general public or to the public at large. It is generated within the communities, but it may not be spread out of the communities. So this is an observation which should be taken into consideration when the legislations are to be passed for protection of this knowledge. The knowledge can be location specific and culture specific, but if the knowledge is to be helping out and it is to design and derive some strategies or plans which are to be executed for the public at large, it should be well in advance communicated to the public, and the local people should also be aware of such knowledge. This knowledge provides legal decision making because of the importance of this knowledge. There can be survival strategies which are hidden of the particular knowledge system. The knowledge also concerns about the critical issues of life which can be handled, and the problem solutions. So the solutions to the problems can be helped out with the help of using this particular knowledge. It is a dynamic and based on innovations, adaptations, and experimentation because someone have experienced something and based on that the experiments have been offered and based on that only the knowledge has been derived. Some examples of that can be, for example, in Mahabharata, we could have experienced that the birth was done with the help of test tube baby form, which now we see that it is a new kind of way in which the babies can be born. But in Mahabharata also we could see that the 100 Kauravas were taken birth with the help of the test tube baby form. The same is the case with the legend of Ramayana, where we could find that Pushpak Viman, which is an example of aeronautics and the astrological well being of India, it could be seen that the India was rich in such a type of knowledge, but it was not documented in that form and it was not communicated in that form, and that's why the protection of such knowledge is the need of the hour. The government of India is taking into account some or the other way few steps for the protection of this knowledge, which can be emphasized through these examples. So TKDL, that is Traditional Knowledge Digital Library, which has been formed by Central Government of India, which holds the knowledge of the medicinal components of traditional knowledge like Ayurveda, Unani, Siddha, but it lacks into the other parts of the knowledge which cannot be covered under TKDL. So it will be helpful to prevent the misuse at International Patents Office, but it is not covering all the aspects of traditional knowledge as such. Section 3P of Patents Act 1970 also states about which can not be called as invention and how the provision can be mentioned to have the protection of traditional knowledge, but there is no direct impact as such to a specific type of traditional knowledge. It is only governing the patent perspective of it. The Biological Diversity Act also governs the protection of knowledge, but it is restricted up to the biological resources, like, for example, genetic materials. So, only a specific part of traditional knowledge has been protected under the Act. The Geographical Indications Act 1999 is also specifying the geographical location and quality associated with the traditional knowledge. But if the geographical locations have been changed, then obviously there will be change in the protection perspectives of that particular knowledge. So, from the case studies which have been studied, there was a battle of turmeric. The turmeric case law is a very important case law in where India have fought for the traditional knowledge and it should be named under the Indian Legal Act. So the turmeric case, which was been against the US scientists, we have won the case, but we have not been registered for that particular turmeric as an Indian traditional knowledge, which was a need, and it could have seen because this case has been delivered and this case has been emphasized on. Other case like Basmati rice case is also one of an important case where we are looking for the patent and we are want that there should be protection for such kind of geographical indications under the particular Indian law. As per Government of India, the literature review which we have gone through, there is a bill which is passed called as Protection of Traditional Knowledge Bill 2022 by Shashi Tharoor, which is specifying the need of protecting traditional knowledge as per the provisions of the Act. The bill also talks about the establishment of NKTK, that is the National Authority of Traditional Knowledge, which should be set by the central government, and this body will take care of whatever is the purpose of the act, how it should be established, what kind of legal provision should be made, how it should be defined, because traditional knowledge cannot be defined in a single statement or in a single word. It is a vast term which comprises of so many elements. The bill is like in a pipeline which has not been approved yet to prepare the final act as such, because so many controversies and there are so many inclusions and suggestions and observations which are needed to be done for preparation of this particular act. From this research, we could conclude that India is rich in its knowledge, But India lacks in protecting this knowledge due to various reasons, maybe political reasons, maybe geographical limitations, maybe the documentary reasons. There can be n number of reasons for such. But the law should be implemented in such a way so that it should be provide the protection to this cultural heritage of India. The legal system should be strong enough to tackle the cases for biopiracy, misappropriation, and misrepresentation of knowledge. Correct measures should be taken so that it should be passed on to the upcoming generations. India's position in the world can be strong if the traditional knowledge is duly respected by its own citizens as well as it is clearly gone through the scientific techniques and then practically it should be implemented in the lives of the people. This is the possible way in which the knowledge can be passed on to the youth of country by explaining the real meaning of the facts and not keeping any blind folds and not keeping any hidden parts in such a knowledge. So there are some suggestions and takeaways from the research. There should be some specific legislation which will safeguard the traditional knowledge of India. The provision should be made so that the provision of legal actions will be taken as well as the legal remedies should be done to handle the cases to counterpart the traditional knowledge. The documentation should be made in such a way so that it should be acknowledged under the name of India. The cases should be solved within the specific period of time so that due justice will be made or given to the people who are suffering from the losses in time. The law should cover various fields unlike existing which are not covering some specific elements. The implementation of law should be done as early as possible and in order to avoid any delayed repercussions of not protecting such a valuable knowledge of India. Thank you for giving me an opportunity to present my research paper. Thank you.
Thank you, Devashree, ma'am.